Yep, let's
Okay.
go live. Welcome, everybody, to a new week in Senate Economic Development, Housing, and General Affairs. We are today beginning to walk through, we're going to divide our day between labor and housing. And we are going to begin by going through some of the labor bills that are on our wall that have been introduced, and two bills, or possibly three, that are in and some additional pieces that will either be coming to us from the House or that we are considering. But we have three draft bills that Keisha has been working on hard, and with Sophie, and we're going to just walk through the elements of those. I hope Keisha will be here to join us. So we're going to begin though with, and we'll hear more about this when the commissioner's with us. I think it's on Thursday. Is that right? The commissioner's here on Thursday.
Yes.
I think at 8:30, which is what you and I talked about. So we're going to first chat about at 6, then we're going to move and this is just to give you a notion of what these bills entail and what they propose to do. And then after we hear them all, we will we'll begin to discuss what we both have interest and our time is short. I appreciate that. And it's not for lack of our working pretty steadily at all this. But it was me. No, it's okay. So we are going to look at the three bills that we have actually introduced, and one of which we have discussed a bit, and one of which we haven't, and then go to Keisha's three bills, and then quickly touch on what maybe we know that the Department of Labor has a technical corrections bill, which they're bringing to us on Thursday morning, which is our Labor Day. So we'll be expanding on these. We'll be expanding on S67 on Thursday as well. So this is to give us really a notion of what is being proposed at the moment and all that we could possibly consider before crossover. We may not be able to do obviously all of this. Some of this we continue to work on. If we get a labor bill, we can continue to work on this and send it back to the House on the labor bill. So it all is not lost if we cannot take it all up at the moment. And Megan, I know I owe you an email, so I apologize, but I just can get back to it. You know, one of those flags that we didn't work. So, Keisha, I just said we're going to look at all these, walk through every bill that is being considered, and then we will come back and discuss which ones we want to address now, what we may want to attach on when we get labor bills from the House, which we may do. Some things just may need some more time. So, Sophie, with that, why don't we start with S6?
So S6 is to repeal the authority that the Commissioner of Labor has right now to recommend a sub-minimum wage for individuals with a disability. And this is something that's allowed under the Fair Labor Standards Act at the federal level. And it authorizes the Secretary of Labor to issue certificates that allow employers to pay sub-minimum wages to workers with disabilities. But as my understanding is, Vermont has not requested any of those certificates. There are currently no, in other words, the Commissioner hasn't exercised the authority that the Commissioner has under the statute. A lot of other states have already acted at a state level to revoke that authority. There was, under the Biden administration, there was a rule that was going to go into effect, I think, right before inauguration. I'm not entirely sure what's happened with that, but would have revoked it at the federal level as well. The interesting thing is, right now under Vermont law, it would actually be a violation of our current law to discriminate against somebody with a disability if you were to pay them not the same as someone else doing the same job, simply because they had a disability. So we already have that protection in the law to protect individuals with disabilities. They're protected under the Equal Pay provisions of the Fair Employment Practices Act. But this would simply be revoking that authority that the Commissioner of Labour has.
So it makes sense to get rid of, to synchronize our statutes. May I ask, do you know when this authority was passed? How old is this language? Sorry, I should have asked you.
No, that's fine. So we should tell us.
I just want to pass judgment on previous generations.
So it looks like maybe 2001
Interesting.
is when that whole statute was amended. So I'm not entirely sure when it was. 1957 was the original statute. So yeah.
Madam Chair, are you planning to put this into like some omnibus bill or?
Yes.
Okay.
I mean, or we could just do it on its own. It's pretty straightforward. I'm waiting also to hear what the commissioner says because he felt this was pretty straightforward. I think it's kind of, as you suggest, crossing our T's and dotting our I's and making sure we get it all statute here.
I'm curious what the original intent of the bill was, or what was the genesis of the original legislation.
I actually know that.
I think so.
So it was originally to do with injured veterans, actually. And it was a way, I think, to encourage people to hire them into the workforce. But it originally, I think, came out of injured veterans out of World War II, is my understanding.
In 2001.
No, the original bill was 1957,
Oh.
but I think that was the original intent.
So it was really designed with a relatively good purpose, which was to encourage people to hire.
Right.
Veterans.
Right.
But at a sub minimum wage. I mean, it's not just a
That's the
benevolent.
kicker.
Right. Well, now that
It's a big-
means.
It's gotta be a bigger story.
Benefit veterans 12 years after the end of the war.
Yeah. I mean,
The pace the legislature operated was the same then as it is now.
Thank you, Ray.
that was. Yeah. I mean, I was just, I
Yeah,
remember seeing that.
and
in something.
Korea too. I mean, there was sort of,
1953.
Well,
yeah.
so I'm trying to kind of like take this a couple of orders beyond what it looks like, and that's maybe some disabled were hired to give them a place to go. Maybe they weren't capable of really functioning in the workplace. They wanted to create a place for them to go, and this might have the adverse effect of doing away with that opportunity. And I'm wondering if there's a negative consequence there that we're not.
Anyway, I think the commissioner will speak to that. We have many encouraging programs for employers to employ people with different types of disabilities. You remember in 1957, we were a much more heavily manufacturing world. So I think you're right. I mean, just the workers would have had to be physically probably a lot more able, and this might have encouraged them to do a lot more administration work or other types of work that they were perfectly capable of, but should have been paid an equal wage. When was our equal wage when were our equal wage statutes enacted?
I will come back, I can come back and give you.
Yeah,
And this-
do that. I think that's just a question that we
Yeah.
because then no matter what, you have to be paid the same.
Well, 495 was kind of where the Fair Employment Practices Act started from. Yeah, I mean, it's many changes to it, but 1963 was when 495 was added. Yeah.
So if I could kind of follow up on that, if there's a agency or a group that thinks that there's an adverse effect to this, certainly want to welcome them to testify to counterbalance. I just wonder if there's an adverse consequence doing this if or not.
Yeah, I think the commissioner will testify on Thursday to some of that. I don't think it's been, anyway, I'm not going to second guess.
It's sometimes been the practice of a committee member to go seek out the chambers and others to see if there is opposition and they want to make sure they feel welcome to testify. But often, if they're doing their job, they know it's being discussed, and I just doubt someone's going to come forward to.
Okay,
But
well,
if
that's
you-
the case, good. There we go.
But if you'd like to chat about it with the commissioner ahead of his testimony on Thursday to make sure he touches on that, that would be great. And
Thank you.
The two things I heard Sophie say was why I'm really comfortable with this is A, we haven't used this. This hasn't, the authority hasn't been invoked. And B, it just it conflicts with our other since past statutes since 1957. So I'm fine with it, but happy to sit on it to see if anybody has any objections or would like to be heard on the topic.
Right. And I know the commissioner is gonna touch on it on Thursday, so that's the first one.
Just a question.
Yeah, right.
Also, as I read the statute, the commissioner has the authority to recommend, not to do.
It's
So
to get,
presumably he'd be recommending to the legislature.
it's to, I think it's to the, it's under the Fair Labor Standards Act, so it would be to the federal,
Who would we be recommending it to
to the Commissioner of Labor at the federal level.
at the federal level?
Yeah, because they're the ones that issue the certificates.
And other states, have other states done this?
Yes, I think many, and the last time I looked, I think it was something like maybe 37 states, and some of them it maybe are proposing to do it. I don't, so I again, I can double check if you want the exact numbers, but it's something that's being done. And the federal administration was going to do it, I just don't know.
They were going to recommend an abolition, you mean?
Yeah, it was scheduled to be removed.
So if we could find that out by Thursday, that would be great. This was asked, a constituent of the Windsor district that asked us that was following the proposed federal elimination of this, asked us to make sure we did it in Vermont, got it all our statutes here. So that is why it's been requested here. Anything else? So more to follow on Thursday when we pick this up.
Well, I think the only thing worth understanding as a committee better is, I imagine in the early 2000s, it was updated because of SFDI law that, people can only make a certain income and keep their social security disability. And it would probably be worth us just making sure we know the SSDI threshold. For a lot of people, they want the dignity of it. And again, we haven't used it, but we should better understand the situation for people trying to work who also receive social security disability. Right?
You don't hit that benefit.
Right. And if that plus is employed, yeah. Great. Thank you. So I think we have S37. We talked about this.
Short one. I'm asking county to reprint.
You can just leave me.
Thank you.
Okay.
Oh, wait a minute, this is 48.
I've got
I
S37.
think they're both there. You're.
Oh, I'm sorry. I got two. Okay.
37.
Okay. 37 is what we're chatting about first.
Oh, okay, let's do that.
Yeah, great. I don't know.
See.
Okay. We have begun discussing this, but Sophie, if you take this through, we heard from Colin Robinson, and we began discussion of this, but this is another labor bill that's in front of us for discussion.
Yeah, so it has two key parts to it. So the first one is that wages earned for work that would not qualify an individual to receive unemployment insurance benefit shall not be counted when determining an individual's weekly unemployment insurance benefit amount. So it looks like a tiny change, but it has a very significant impact. And this is under the disregarded earnings. And so I can't remember if the commission, I think he did touch on this a little bit at the same time when he was here.
He did.
So I'm sure he will talk about that more on Thursday. But essentially, if someone's receiving unemployment, there are certain things that you can be earning money that doesn't count towards your earnings in terms of calculating the benefits. And so what this would do is if, for example, you were doing seasonal work and you were off for 10 weeks, and as we heard last time, if you're off for 10 weeks and you know for sure you're going to return in 10 weeks, you don't have to look for other employment. But in the meantime, you could actually be working as an independent contractor or whatever, and you could be using those, using that, living on that money. Right now, that would count. This would take that money out of the calculation. So you would essentially be able to collect unemployment insurance and be working, as an independent contractor or whatever during those 10 weeks. So, it's a, kind of a policy question in terms of what direction you want to go in. But it looks like a small change, but it has a pretty significant change that I'm sure that Schmidt can talk about.
But can you remind us, we do make that allowance for other industry.
There are other things that get excluded.
So like if you're in
Compensation.
seasonal construction and you receive UI, you can still earn other income and then go back to your construction
Right.
job.
So the incentive is really to encourage people to, even if it's part-time employment, whatever, to be earning. But this would exclude the one big example that, as I understand it, is particularly if you're working as an independent contractor, if you set yourself up as an independent contractor, you can be earning and also receiving sort of full unemployment benefits.
I guess I'm just trying to understand if you're saying that would be a different treatment for this particular category of worker than other seasonal workers.
It's not limited to by category of worker. I was just using that as an example. So this is just taking out any work that the employer does.
The employee.
Sorry, thank you, the employee that the employee does, and then excluding that from the calculation. And so that it seems like a small change, but it has a big impact, is my understanding.
Right, but I think to go to Keisha's point, it would be great for us to get an understanding of the universe of jobs where that is also excluded. Construction, ski industry. I mean, there are bunches of things that are seasonal where it would be great for us to understand that this is not an extraordinary ask necessarily, but it's added on to other jobs that already do this.
Right. So right now, they disregard 50% of your reported gross wages earned. And so this would exclude those earnings from that calculation.
Great, Tom.
My question is along the same lines as we just raised, Chair Clarkson. So section 1 is not narrowed to just the instructional workers. This is across the board. Okay.
These are really two distinct pieces that are in
Oh, I see.
So my next question would then be that $5 million to $41 million range of estimates that came up in the testimony on this bill so far is really just as the second part. So we have no idea what this potential cost would be on our employers who have to pay dollar per dollar how much is drawn out of the unemployment insurance fund. So that's a big question mark. And
Have we sought the answer to that question?
I believe we did, because I think that, and I apologize if I don't know what happened with JFO, but JFO was going to weigh in on that. So do you remember from our conversation?
I don't remember that.
You're absolutely right, that we were going to, let's just touch base with them on that, because
my point,
I can't remember where that was left.
the number that came up last time did not include this
Right.
consideration. So this bill could do even, because that would also affect unemployment insurance drawn against school districts for positions that aren't instructional. So this has some serious implications for employers in Vermont.
Can I just make sure I understand that? I mean, this bill keeps being summarized as expanding UI coverage to include school support staff, but this seems like a much bigger headline here.
Right.
This is separate. This is about,
These are
everyone.
two separate provisions.
okay,
So this is for
It came
policy.
up. It came up in the context of the school support staff,
sure.
and then it was, kind of was blended in there. But it is,
But it's basically
covering
for all
two
seasonal workers.
It's to do with what gets counted as gross wages when you're calculating benefits. So what's excluded and what's included. And right now, again, there are certain things, if you do them, are included in your gross wages. And so, if you get the disregarded earnings, you get 50% of that is disregarded, and then they calculate, what the benefit is. And so here, it would just disregard more of your earnings. That's the simplest way of saying it. So it would increase the amount of unemployment benefits that are being paid out.
So I have reservations about this. I want to hear from JFO on this topic.
Yeah, look,
I would need more testimony also.
yeah, and the commissioner touched on his concerns with this as well. So
I see, two of us here are sponsored, I remember the purpose of this bill being about UI for
Support staff.
support staff. I
We
just
kind
want
of
to
had
say
that
for the
We
record.
kind of had that conversation last time because I
Mhm.
think that was sort of what the understanding was. And then it was realizing, oh no, actually, this is a very significant change that's happening in the
Yeah.
first part too. So there was a question about whether to separate,
Right.
you know, whether the committee, if they wanted to move forward with the school support staff, whether this was, you know,
Right.
Yeah, I'm just wondering if we've heard any testimony about this first part.
not really, other
Okay.
than what the commissioner sort of on the fly was providing.
Okay.
That's,
I think the thing that we want to know from JFO is, looking at this, how can we at least estimate in broadest terms what this would cost? And if it were limited to simply the school employees, what would that cost?
Absolutely. That is the question we will ask now.
Do you mean both parts separately?
Yes.
The school employees can't draw down unemployment insurance at all right now. So
Right.
this would
So that-
compound if
yeah.
the other part went forward.
Right.
So you need to know essentially the two numbers.
But also it would
At
be,
least as best we can guess.
so yes, I mean, it would be a pretty big guess on part one, which is how many workers actually would qualify for this.
So I guess just, I'm curious as the lead sponsor of the bill, because I was looking back to see, what was the intent of the lead sponsor of the bill? Was that part of your intent in this bill?
No, part of our intent is, because you're with me on this, our understanding was this was about the support staff of the school.
Okay.
So I had not fully appreciated, I don't think any of us fully
Okay.
appreciated that it also
it was
included
a rerun of
the
a,
additional season.
it
Ah,
was a rerun of a bill that had happened before.
Gotcha.
okay,
And so the focus was on the school support staff. And then
okay,
with the rerun, it was only as we were going into the conversation
okay.
last week that it was like, oh, actually, this is a pretty big
Actually,
change.
this-
And
So we will get from JFO both, and hopefully by Thursday we'll have a notion of I don't quite know how they're gonna calculate something, in section one.
it may be that the Department of Labor has that information
Yeah.
because they're currently collecting, they're currently collecting the information and then there's a calculation in terms of what gets disregarded.
Yeah.
If I may, I just worry trying to have both of these conversations at once is just too much.
Yeah.
And because we've all articulated that our intent was the second part, I might have some sympathy for the first part, but that's a huge discussion about the UI fund, not a discrete number of employees.
I don't disagree.
I think it would take JFO's time, maybe unnecessarily, to try and calculate the first part, when they don't have a lot of capacity. So I just suggest that if we are pretty clear that our intent was the second part, that we not ask JFO to do the extra work of the first part.
I'm happy to find out what their notion is of what time it would take, and if it's gonna take them too long to not bother with that.
The other way to calculate it, take a look at some other state that does it and see if they have methodology to do that and what their experience has been, particularly if there's a state, for example, who's changed within a reasonable period of time, what was the difference in the amount before and after?
Yep, I will ask Patrick after when we go on break. Thanks.
So the second part was the one that was really the focus of the discussion last time, which was around the school support staff. So I don't know if there's anything else you want me to add on that bit.
No, I don't, I think that for some of us, there's great interest in pursuing the second part of this. And we will know more, and so maybe let's wait and find out more and discuss it again on Thursday.
Okay.
Do you want me to communicate to the commissioner that we're not necessarily looking at the first part?
I'm
Are you gonna
happy
do
to,
that after you.
I'm happy to chat with him about it, because we're gonna chat about S6. So I will be in touch with Michael today.
I did not bring S67, the minimum wage, using the livable wage, because I know that's a focus of what we're going to be talking about on Thursday.
Right, we are. I'm just gonna tee it up. And if we could get a copy, I need 67. That would be great, just so people can read it. As everybody did this summer, we spent a lot of time as we campaigned talking about affordability and the challenges Vermonters are facing in terms of costs of people around the country. Inflation has been very high and costs have been rising faster. I was stunned to see eggs at our local grocery store now $9.89 a dozen. I think we're all feeling and appreciating the impacts of inflation. There are two sides to the equation, however. There's what things cost and what people earn. And we know historically, and at least this committee has looked at this. We have been the committee that has proposed increasing the minimum wages. Is the committee that supports jobs and enables jobs that enable good pay and support incomes of families. So Vermonters have been paid historically also about, this committee has heard, about 20% less
An extra one.
across sectors, not all sectors, but across sectors. Vermonters have been underpaid about 20%. This bill looks at setting the minimum wage and tag it to the livable wage, which is calculated every 2 years through the basic needs budget. Having updated the technical aspect and have updated the components that go into the basic needs budget, it was my feeling that if we're really going to begin to help get at Vermonters earning more, we need to put our money where our mouth is and set the minimum wage to be the livable wage, a blended figure between the rural livable wage and the urban livable wage, which is what the basic needs budget does, and peg it at that for next January, and then have it progressed by CPI going forward. And that is really just what this bill does, is it says, if you believe in the calculation of the basic needs budget that calculates what it costs to live in Vermont, we should be owning those costs, what it costs to live here, and saying, if you're going to live here, this is the minimum amount you need to live on. And that is what the livable wage is that's calculated by that basic needs budget. So that is what is proposed here for us to discuss. And we will obviously have the whole range of people who are impacted by that. It is.
You mean you want to give the significant testimony?
I'd like to give it some testimony to see if this committee is willing to do that lift. And we have a biennium. I realize that, but I also realize that if we're going to try and affect what Vermonters earn, and which is the other piece of that cost, the affordability question, we also have to look at what they're earning. So that is, we're going to get more testimony. We'll walk through it on Thursday, and we're going to get the Public Assets Institute in, and then we obviously have JFO, which does a lot of work when we went through this with the minimum wage bill. And
I feel like Randy and I are like very intently looking at each other. We might have the same thing to say. I don't know. So I just want to rewind to some history, at least for Senator Weeks. We tried to look at this just with people we pay through state government. And even that was too heavy a lift for us, which makes me sad. Because we have a lot of really important social service workers and home care workers who are not earning anything close to a livable wage. And that would have such a significant impact on the state budget that we didn't even make it that far. I'd really like to see us focus this year on getting rid of sub-minimum wages. Which when we've talked to Matt Barowitz, and we don't have, I think, this year's information, and we won't till March, but when we've talked to Matt Barowitz, we've asked who isn't making even this minimum wage, and that has been instructive, and it's a lot of the folks who are receiving a sub-minimum wage, by our current laws. I feel like we have a lot to do before crossover, and I would advocate that we not spend time on this one in the next month when we have so many other things to do. because I don't think this is going to go anywhere.
It may not,
Here,
but it's a discussion we have to have, I think.
you have a time management.
No, I absolutely appreciate that. And that's why we're having this discussion, so that
So
we
that's
can
my
all get a sense of where we are. But I believe I've heard conversation as we have gone through the housing crisis discussions, how, you have to be earning X amount to be able to afford a 1-bedroom or 2-bedroom in the Upper Valley. You have to be earning at least $21 to $23 an hour to afford a 1-bedroom apartment. So yes, I appreciate the fact that this would be a heavy lift. I also appreciate the fact that Vermonters need to earn
Okay, but
a minimum amount.
this is the Economic Development Committee, and there is no lead up to this change. This would be a huge jump in wages. And we do have to listen to economists who will tell us that that causes a lot of inflation. So we can't just kind of ignore economic science
We
here.
aren't ignoring anything. I am just putting this on the table, and we are not necessarily trying to be able to have the bandwidth to deal with this session. But I just have put it on the table for something for us to be thinking about.
I really
When are we gonna
hope
start
it's not on the
meeting?
agenda.
We're going to have the public assets in on Thursday.
That's again, it's a one-sided view right off the bat.
We'll have all sides. We always have all
I
sides.
Well,
just,
again, if we take the time to do it, and I agree with Keisha, we don't have time to do this, and it's not gonna go anywhere. We don't have the money to do this.
I really like us to focus on the
Effectiveness of the
minimum
economy
wage.
is so significant. Can't do this.
Thank you. I appreciate that. And that is why we're having this conversation. So I appreciate that. So having heard that, I think let's turn to Keisha's first bill, which also addresses sub-minimum wage. And Keisha, if you,
Can I
yeah,
make this one comment? In the itinerary, the agenda for the week,
Yeah.
if it's possible, because you keep referring back to Thursday and when we're gonna hit some of these bills. If that particular time slot can be annotated for that particular bill,
Yeah.
it would allow me as one new member of the committee to be able to go back to old notes, review the bill, et cetera, in preparation for that meeting, so we know exactly that that's the bill we're gonna touch on that after. That'd be helpful. It's kind of
I thought you were gonna say something else, which is we should devote that to other pieces of this bill that we're actually gonna move.
thank you. We'll certainly take that into consideration. So Sophie, why don't we shift to Keisha's first bill, which I believe addresses another sub-minimum wage.
Yes, so this bill would remove the exclusion of agricultural workers from the exclusion from receiving minimum wage. In other words, it would make them eligible to receive the state minimum wage. It continues the exclusion for agricultural employers, parent, spouse, or child. It also amends the exclusion of bona fide executive, administrative, or professional employees to those who are paid at least $1,128 a week. So in other words, those who make less than an annual salary of $58,656 would be eligible to receive overtime.
Which was
Was part of the federal, under the Biden administration, part of the federal Department of Labor's rulemaking. And they had the annual amount, currently it's like in the 35,000 range. I don't know the exact number right off the top of my head. But as of July 1st last year, it went up to $43,888. And then as of January 1 of this year, it was scheduled to go to $58,656. And then the federal rule got struck down. I think in November, it got struck down towards the end of the year and retroactively to the change that had already happened in July.
This is struck down by the courts.
Yes.
What basis was it?
So for that category of employees, when you talk about executive, administrative, professional, that exemption, that those employees, there's a two-pronged test. So one is a salary threshold and the other is what's called the duties test. So do your duties, what you're actually doing, qualify you for that
And
exception?
you have to qualify to vote.
You have to qualify for both.
Mhm.
And the federal court that struck it down, I think, was focused on the Biden administration salary threshold, basically sort of preempted the duties test. So instead of having a two-pronged test, it effectively resulted in just a salary
So
passed.
just to follow along while we go through this, we passed this out last week or the week before. You should have it in your files. It's draft 1.2 of 25-0652. And we passed it out, so you have a copy of it. Somewhere. I have it in my labor files. So, but we have this summary too that we can work.
Oh, you have it too.
Right.
Okay, yeah, I know.
Yeah.
Heidi,
You want
most
me
of
to
the
keep
last
going?
things I
Yeah.
might need.
So section 2, provides that agricultural employees who work for an employer that receives state grants shall be paid overtime for work in excess of 60 hours a week. And again, that would apply to the agricultural employer's parent,
Yeah.
spouse, or child.
Right, just for people's notes, if they do it by date, last time we discussed this was on the 5th of February. And we got through to, I think, the beginning of section 2, and then we had to end.
Right, and I'll just say, I'm certainly holding all of this lightly for discussion. The two of those act provisions were kind of where I'm not looking at Randy, where our committee landed in terms of if we had, specific recommendations to support our dairy industry and our agricultural workers, we would not be looking at unionization. We'd be looking at the things that actually give people quality of life. And the wage piece was obviously, I think a lot of our dairy folks said they don't pay less than that. So it didn't seem like the good actors we heard from, which was at least probably 75% of the industry were paying less than minimum wage. But it's hard to hear from the people who would be paying less than minimum wage. And the 60 hours a week threshold felt, at least to me, and I think it came up on the committee, that it was a public safety issue if people were working past that, without being able to make better decisions
In
about
terms of
it.
what was actually being paid, I came away from the work that we did with the gross uncertainty as to whether the information we had was accurate and sufficiently complete to make any judgment.
Right. What I think would be interesting is if this is out there, hopefully we then hear from someone who says, no, I need to pay a sub minimum wage,
Or they continue doing it anyway.
that would be,
I suspect.
that could happen. So yeah, I just, again, I'm putting this out there, but that's the context. I told the task force I would put these ideas on the table at the level where I thought we got to the conversation with incomplete information.
Yeah, my sense was a lot of the information that came from the dairy industry was muted because the dairy industry, particularly those who were not complying with certain laws, didn't want to be very public about what they said.
Right.
And did they even testify?
Yeah.
Were they there?
Mhm, they did.
Okay.
Some people were there.
It was an
I'm going to
industry.
say the industry as a
Yeah.
whole was there. I
Right.
had my doubts.
They kind of said, they just kind of said, we don't know anybody who's paying less than minimum wage. That would be non-competitive. And then Migrant Justice said, we surveyed our members and about a quarter reported being paid.
Yeah, and the others said that they weren't. So
Mhm.
it was tremendous conflict and tension with what we heard, which is why, as I said, I kind of discount what I heard.
Keep going.
Yeah, let's keep going.
All right.
So obviously on this week, we'll chat about witnesses for this from both the task force and other people.
So section 3 is provides that employees who separate either voluntarily or involuntarily from employment would receive any unused but accrued vacation leave in their final paycheck. So right now employers can choose to do that, but they're not required to do that. So if you've got 2 weeks worth of vacation, you're either let go or you leave. You could lose the accrued vacation that you have. This would just require it to be paid out.
Yeah, this came from a constituent and I think I was under the impression that you do get your unused vacation.
I think most, I don't know, at most do. It just seems to me that
Mhm.
Well, and depending what's involved in the separation, it may be not pleasant and therefore there may be some retribution. So it would be good to have it required. Yeah.
You're saying currently there is no obligation that an employer can choose or not choose to give
Right.
a vacation, and this would mandate it.
Yeah, I mean, if they have it in their handbook or something that they do it, then they would need to do it, but there's no overall obligation to do it.
Even if dismissed with cause, would this override if somebody was fired because they
I don't
did something egregious?
So this would be either whether you do voluntarily or involuntarily. And then the timing, again, under section 3, depending on the way you leave your employment, depends on when your final paycheck is issued. So if you're fired, your final paycheck has to be issued very swiftly. If you voluntarily leave to the next regular pay period.
I mean, more amenable just clearly if they voluntarily leave, but in circumstances where somebody is dismissed with cause, I would be concerned that they would have to be pay out this vacation if there was theft, if the employee had taken resources. So I think that's worth more discussion.
Yeah, that means the other side of the coin is a person getting vacation, they're earning it as they're there. And so theoretically, when they get paid based on the number of hours they've worked, the time they've worked, the weeks they've worked, and it would have been earned. And I would think that before you say that somebody's stolen the money and you want to recover it from their vacation, you ought to be able to have some evidence to prove it independently.
Is there consistency in how employers track vacation days? Because that can get pretty squishy with smaller enterprises.
My guess is they're pretty coveted, so they are probably tracked closely.
Either that or you, and again, I'm not typically in favor of adding more and more regulation, but there ought to be a process by which it can be measured.
And I can try to find our constituent who's.
Right. And also, if you've earned it, I think you have a right to it.
If you get fired for cause, I hate to. That's where I have a concern, because I've been in those situations. Not that I was fired.
Do, no.
Okay, workers' comp.
Right, so workers' comp, this covers the next few sections. So the first one would be including the market value of health insurance in the calculation of wages, which right now it doesn't do. So when the calculation is done on what the average weekly wage is, there are certain things that are included that are listed: board, lodging, fuel, other advantages that can be estimated in money. And so this would add the market value of health insurance into that calculation. And again, I'm not as familiar with how that would play out. That may be something for the Department of Labor to talk about what the actual impact of that
Presumably
is.
there'd be some sort of a JFO view of this and many other things, because I have a feeling that that's going to be a very large cost.
Right, that would inflate the amount, right?
And I think my for
The next piece is adding a definition for medical case management. So right now, carriers of, the folks that handle the workers' comp claims, they can choose to have claimants go through medical case management. What these changes would be that are coming up in this next section are allowing a claimant to request to have access to medical case management. And medical case management, as I understand it, it's for people that are very seriously injured, have traumatic brain injuries, or maybe lack the ability to really understand, navigating the complexity of the healthcare system. So this would be, these changes that are being requested are intended to make it available for claimants to request, rather than it being up to the insurer, the carrier, to decide whether or not somebody gets these services.
what is medical case management fee?
So it includes medical case assessment, including a personal interview with the injured employee, assistance in developing, implementing, and coordinating a medical care plan with healthcare providers, in consultation with the injured employee and the employee's family, and then evaluation treatment results. The goal of medical case management is to provide the injured employee with reasonable treatment options to ensure the injured employee can make an informed choice.
And that's not required now.
It's not required. This is really just saying, could the claimant request it, as opposed to it being up to the insurance, the third party insurance carrier. to decide this case should have.
We know that this is, whether this is or is not common now.
I don't know that. Yeah.
Keisha, do you know this? Cause it's part of your,
Yeah, no, I mean, I think we've had a labor attorney in before who handles a lot of local workers' comp cases who'd be happy to come in and say, this is kind of, we often hear from folks, hey, what's the situation on the ground? And this came out of, here's what people are facing that's not working. So it's David Mickenberg can find that attorney.
Kelly's massacre.
Yes. Is it Kelly? Okay.
good memory. But this doesn't exist now as an option.
It doesn't exist as an option for the claimant to request it. And just to follow up on Senator Brock, the definition that they're looking to put in the statute is currently the definition that's in one of the workers' comp rules. So we'd just be moving it into the statute.
Great. Let's keep going. This is our
Yeah.
first-
So section 5 is, I would add a requirement, this again, under workers' comp, would add a requirement that, for injured employees who don't speak fluent English, that the employer pay for translation services to ensure that the injured employee fully understands their rights and can participate in their treatment. Section 6, this just goes back to what we were just talking about with the, claims management. And this just adds in, right now, the request for pre-authorization to determine if proposed benefits are necessary. We would just add in for services, and the services being the case management, medical management that we just talked about.
Isn't that a benefit? A service? Services are benefits.
They're just adding this in as a separate definition as a service. Because it's a service, they're not actually receiving, I suppose that's how it's being proposed anyway. It's to have it as a service. And then it has, there's language in the proposed bill around how you would request pre-authorization for that service. So you don't just get it because you asked for it. You actually have to go through a pre-authorization process. And then if the carrier denies the services, the claimant can ask the Department of Labor to go ahead and allow them to
How does this interplay with our bill that we passed last year on pre-authorization? So that's a Jen Carby, Katie McLean. Question.
Yeah.
Right. I mean, workers' comp
I know
insurance
it's
does
just-
function separately.
I know, I'm just curious how far reaching that pre-authorization bill was. In terms of any impact on this.
I think
Maybe not.
health insurance.
Okay, let's keep going.
And then section 7 of this bill would basically establish a system whereby benefits aren't paid in a timely fashion, that there's a sliding scale of penalties that the employer would have to pay if they're late in paying out claims.
Sorry, this is section 7
Section
on
7,
page.
starts on 8, but the detail is on page 9. So it's just a sliding scale that depending on how, and again, it's the more times you're late on the payments, the higher the penalty becomes.
I thought that
We
already existed.
well, we did it last year.
Yeah.
I think at the we did it 2 years ago at the $10 level, and I think they're still seeing late payments. So we can let them.
Yeah, so the current statute is the employer shall pay to the claimant a late fee of $10 or 5% of the benefit amount. And this is just to increase that over time.
So the longer they don't pay,
Right, so
the
it's
more they'll pay, right?
10% of the benefit amount for the second payment that's made off the established date, 15% for the third time, 20% the fourth time, 25% for the fifth and any subsequent times.
Yeah, it would be interesting to see if the $10 actually improved payment speed or not. And because we need, did you get a sense, Keisha, in having this drafted that consequence was inadequate?
I think that's what they could come in and speak to. But I mean, that's what we heard last time and why we passed it at some amount. that they're just not, it's not a priority to pay folks on time in this way. And that has a really significant impact on them personally, financially. And there's a lot of other payments that we require in the state where you can collect, financial damages if you don't pay on time, like rent, et cetera. So
Absolutely. Okay,
Section 8 is unemployment insurance for contingent faculty. I think this was touched on a little bit when
we talked about that, yeah,
right. So this would require, so faculty traditionally are just excluded completely from being able to collect unemployment insurance, but there's some flexibility around adjunct faculty. And so this would be, including that in. Now, right now, in fact, adjunct faculty can collect unemployment. This is really clarifying that. And it includes a definition of what reasonable assurance means. So that was the conversation we sort of began last time around, well, what does reasonable assurance mean? And it's whether you have a reasonable assurance that you will get another contract to teach for the following semester or the following year. And then this includes all the requirements for what reasonable assurance would be. So it's on page 12 of the draft. So things like you have an offer of employment that's written, oral, or implied, made by an individual with actual authority to offer employment. It'll be in the same capacity as the current contract that you have. So it has a list of factors to consider.
So you said they currently can, contingent faculty get on insurance as adjuncts. Is that because they are part-time?
Yeah, and you may not, necessarily, you may teach in the spring semester. You don't know if you're going to be invited back to teach in the fall semester or when you'll next get another teaching contract. So under those circumstances, you would be able to collect unemployment right now.
But full-time instructional roles are not eligible.
Right.
and the difference between adjuncts and lecturers here. Lecturers operate on a multi-year contract.
It depends. I mean, I know that in University of Vermont has lecturer positions, so Vermont State Colleges does
the
not.
law school has a different.
But you're full-time and you're,
I was an adjunct for some time, and
right,
it seems jarring to me that an adjunct can claim unemployment insurance. Why? Because they're still instructional according to the federal regulations, so it's just not against it, but that was
puzzling.
Yeah, it's puzzling for me. But full-time instructors cannot.
Well, I think the state colleges would be happy to come in and talk more about this. And I mean, so many institutions are moving toward lecturers and adjunct faculty. That it's a category that we just haven't looked at in a long time to understand their financial experience and how employers should sort of treat them to make sure they have financial security if they are being treated more and more like.
But they're getting it now. They can apply for unemployment insurance.
Well, I think
They can. I think historically they get denied a lot. They have to go through a lot.
Adjuncts do.
Yeah, just because, then there's, do you have reasonable assurance you're coming back? This would provide clarity as to what reasonable assurance is.
right.
So this, I think, would just make it easier for folks to do.
That helps.
And clearer for what the employer should do to make that person a reasonable
Right. Reasonable
offer,
assurance.
to give them some sense of financial security or not, but they have to
But I would hope at its best, it would encourage an institution to avoid having UI claims, that they would be very clear with whoever's coming back. That they'd have a contract already in place.
My homework outside of committee is I will learn more about the process for the review of those applications. So
for UI claims. Yeah,
that would
that's
be-
great homework.
Yeah, that is good homework. And the difference between adjuncts and lecturers on that front and the contract expectations on both would be interesting. And is there any other group of workers that this that would incorporate?
No, this is just contingent faculty.
So contingent faculty just includes lecturers and adjuncts?
I don't know if there's
Is there another category of?
full-time, I mean, again, and if you're a full-time instructor, but you're told, you've been made tenure, whatever, you could certainly claim insurance. It's unemployment. It's not that you can't. It's
So
always the assumption is that if you're a full-time faculty member, you're going to be coming back year to year.
Is contingent faculty defined somewhere?
I will have to look and see.
Okay, great. That would also, I think, help out for you.
Can I make a suggestion since it's almost 11?
Yes,
I think we need to prioritize language right now that we're gonna look at
And
for
witness.
passage.
Yeah.
And so I would at least ask to finish this list on Thursday during
I
the
would.
time. that-
Great minds are thinking alike.
Thank you.
I am absolutely taking that on board because I'd love to finish, if we could, we just have a couple more pages in this and finish this draft of pages 0652. So if we could just finish this up, Sophie, in the 4 minutes, we have just high level.
So section 9 and 10 deal with incarcerated individuals and it uses the terminology offender because that's the term that's in the statute currently. But it requires that an offender shall be compensated at a rate that's equal to or more or greater than minimum wage. So right now, there's no requirement that if you're incarcerated and you're working, they should get paid minimum wage.
So do you wanna, I feel like you wanna say something. Emily?
I'm observing,
You're what?
observing.
And listening.
Sure. that-
That's all incorporated. Okay,
So,
great.
yeah, and then section 10, we just.
So do we know what they're currently paid? Because I know they're paid all like pittance.
Yeah, I think it varies. It's, I don't have an exact amount, but
We'll get it.
certainly historically, yeah, you'd want to have the commissioner for corrections to come in to look at that.
Okay.
And then the last,
And there are fewer and fewer paid opportunities anyway. That was 3 down.
the last section, is requirements on state construction projects. And so this one would apply to, currently applies to kind of state construction projects with costs exceeding $100,000 or construction projects with costs exceeding $200,000, depending on where the money's coming from. So this would eliminate the current language around prevailing wage and then replace it with new language. And it would require the prevailing rate of wages and benefits payable for labor in the locality where the public work is being performed under a collective bargaining agreement. If there's no collective bargaining agreement in the immediate locality, then it would be sort of the nearest locality to where the work is being done. So that's one element. And then there's another element that is to the extent either the federal Davis-Bacon Act or the prevailing wages that I just mentioned, it would be the higher of the two. So whether the Davis-Bacon Act, which covers federal projects, would result in a higher payment, or whether the prevailing wage under local collective bargaining agreements, whichever is higher, would be the one to apply. And then it has this is a separate piece. It's under the same statute section, but separately, this would require employers and subcontractors with the state of Vermont to keep true and accurate records of all employees working on the project. And
Do they
then
not? do that now?
essentially, I don't know. I mean, I'm assuming people feel not so much like it's going to be in the request, but it requires detailed payroll records, that the records be submitted weekly to the state agency overseeing the project, that the payroll records be certified as to their authenticity and accuracy, the records be preserved so that they can be inspected by the Commissioner of Labor or the Attorney General, and that employees can bring a public enforcement action if that section is violated.
It refers to employers and subcontractors. So a subcontractor who has employed performing work, the liability extends to the employer, the contract owner, as opposed to the subcontractor.
This would require,
In other words, would both have that requirement?
it's framed as it
So
would be both.
does that put a burden on the prime contractor greater than, say, Davis-Bacon does?
I think it would put a burden on them to make sure that the folks are being paid what they're required to be paid under the statute.
Right.
And then there's this,
That's an implication. Well, we'll talk about it when
Yeah.
we get to it, but it does have some
Yeah,
significant financial implications.
I'll just say, we've spent a lot of time trying to get at worker classification issues, especially on construction sites. And this is what more states are doing because it's been so hard for us to try and categorize. You know, this is if we were trying to actually solve the problem instead of gig workers, et cetera. This is usually where our focus is undercutting, people following the law with,
Well, again,
Other
it's
workers.
just something that I
Yeah.
think we should look at and say,
Mhm.
are we potentially creating a bureaucratic nightmare for some employers at this point?
Mhm.
May or may not. It may be common in Davis-Bacon, which is why I asked the question and
Right.
we'll get the answer
Yeah.
when we do this.
I think this was a great, finishing of this particular bill. So we will, finish our walkthroughs of the other bills on Thursday. And we are gonna go on